Hey everybody, this is Alex. This is this week's episode of That Privacy Show. Today we're going to be talking about the ePrivacy Directive, which is basically kind of a sister law to GDPR, although it's been around longer than GDPR. It's been around since 2002. And this is, in most situations, the most relevant law for digital platforms. Obviously, GDPR is responsible for the rules when it comes to processing personal data, but the ePrivacy Directive is concerned with any information which traverses over a public telecommunications network. So that means anything in relation to, just one second, Pat, just a sec. Anything in relation to cookies, so websites, anything in relation to apps or smart devices, IoT devices, wearables, smart vehicles, etc. Yeah, I'm not sure why you're seeing it as crackly, Pat. It's this week I'm using a different microphone, which is a dedicated stand microphone, so it should be okay. Everybody else doing okay there? All right, so I'll continue. So when it comes to the ePrivacy Directive, this is really my baby. This is an area that I really launched my privacy career back in 2008. Was looking at the ePrivacy Directive, otherwise known as Directive 2002/58/EC, in relation to the technology being used in the UK, which was collecting all the information about the websites that an ISP customers visited, and then using that to build profiles to sell to advertisers. This was something which I found really interesting and got very heavily involved in and created a grassroots campaign. This ended up bankrupting $1 billion company, and that shouldn't be in mono. Let me just double check. It shouldn't be in mono. Mono isn't checked. Is that in stereo now? Because now I checked the mono button, so that should be in mono now instead of stereo. Kinu? Are you getting mono now or stereo? Anybody? Okay, thanks Deep K. I'll deselect it again then, since it doesn't seem to be an issue. Oh, alright. Let me put it back on. Is it? Kinu, is this in mono or is this in stereo for you currently? Okay, there we go then. I'll leave it there. Okay, there we go. So this ended up being a huge campaign. It was completely unfunded. And the European Commission at the time said this was the second largest campaign that they'd ever dealt with, in a meeting that we had with Viviane Reding's cabinet in Brussels in 2008. It ended up bankrupting $1 billion company called Form, and really was responsible for a lot of changes that we've seen in privacy and data protection. Okay, good. Kinu says it's now in stereo, so this is all good. And so if we go back to 2009, there was a piece of legislation introduced called the Telecoms Reform Package. And this was what many people now think of when they're talking about the cookie directive. It's important to note that this isn't just about cookies. The Telecoms Reform Package was specifically set up to deal with the issues that we've seen in emerging technologies in the tracking of people's behavior online. So it was added to the Privacy Directive as an amendment. Hey DM. It was added to the Privacy Directive as an amendment in 2009 and came into effect in 2012. And this is where we end up with this situation with the cookie banners. Although I should stress that the ePrivacy Directive does not require cookie banners. This is something which was done deliberately by the ad tech industry as a means to effectively piss off people with consent fatigue, as we call it in the privacy space. So yeah, don't blame the Privacy Directive for useless cookie banners. This was as designed by the ad tech industry in revolt against the ePrivacy Directive. But that's not so much the issue. I'm just getting messages there. Just one second. And yes, feel free to ask questions, as that privacy gal just said. But please keep things polite because she has to moderate the chat, and I don't want to have her too busy. So the ePrivacy Directive was changed in 2009, came into force in 2012, and ever since then, when it comes to accessing information or storing information on an end user's device, unless it's strictly necessary, you're now required to obtain consent. Some would argue that consent was required previously, but there's some ambiguity, which has since been cleared as a result of these amendments. Now, what is often not understood is what we mean by strictly necessary. And strictly necessary, you might as a company think that it's absolutely necessary for you to have Google Analytics on your website, or to have Facebook or Google SDKs in your app, so that you can do things like deliver advertising or profile people for the benefit of various marketing activities. That's not what is regarded as strictly necessary under EU law. When we look at the history of EU law, the necessity test means that if you can do something in a way which is not so intrusive on fundamental rights, such as privacy and data protection under Article 7 and Article 8 of the Charter, then that is the methodology that you must use. There's no way around this. And strictly necessary is an even narrower interpretation of what's necessary. And when we talk about strictly necessary under the ePrivacy Directive, we're talking about whether something is technically necessary to deliver the service which has been requested by the end user. So clearly in those circumstances, analytics is not for the benefit of the end user, not directly at least. You may argue that it is in the long term, but certainly it's not requested by the end user. Advertising is not requested by the end user. Various other technologies for profiling people or tracking them across the website, such as session recorders like Hotjar, are not considered as strictly necessary either, because they're not to the benefit of the end user. Scripts which might, for example, lay out the web page in a landscape format if somebody's viewing it from a desktop or from a tablet, or in a portrait format if somebody's viewing it from a mobile device, that may be considered as strictly necessary because it's facilitating the request by the user to provide them with the content in an accessible format. Other things that might be strictly necessary when we're talking about accessibility, for example, a screen reader script may be considered strictly necessary because you're meeting the accessibility requirements of EU law by making that content available to people who may be blind or may have difficulties in reading. Other things that might be strictly necessary would be scripts which monitor things that people put in their shopping cart, because obviously as you traverse through a website, you go to different pages and you add things to your shopping cart. You want those things to stay in your shopping cart until you go to the point where you finish your shopping and you go and purchase those goods. So that would be considered strictly necessary as well, although with the caveat that abandoned cart software does not meet the requirements of strictly necessary and actually requires consent, but we'll talk a little bit more about that later. Other things which might be considered as strictly necessary might be a login cookie, which preserves your login username and password so that you can access areas of the site which require this type of authentication. So private areas of the site, for example, or in the case of a shopping site, to be able to do shopping and attribute those things to your shopping cart might also include a login cookie. So strictly necessary is all about what is required for the end user. And you can see here I've got the BBC's website open, and we'll talk a little bit about the consent banner in a little while, because that's another issue I want to talk about, is these consent banners and where they fail from a lawfulness perspective. But initially I'm just going to quickly open up. So you should see a change on the screen now. You should see a big white panel on the right hand side. Do let me know if it's not there, please, in the chat. Can you all see this developer tools? Yep. Okay, so if we go to the sources tab at the top of the development tools here, we can see in this case, and I've turned off all my privacy protections in my browser here, which is perhaps unwise given the situation with the BBC. But just to purely illustrate the types of things that I would normally have blocked, which are in here. So for example, there's a whole bunch of stuff in here, CDNs and Google user content, Chartbeat. There's other things in here as well with regards to fonts, Optimizely, which is a piece of software for doing things like A/B testing. And when we go through these, we can see that there's several things which are hosted on third-party domains. So here we have adsafeprotected.com. That's a third-party domain. That's not the BBC. Optimizer.com is not the BBC. Fonts.googleapis.com is not the BBC. So these are all third-party domains. And what's important to understand is whenever you embed content from a third party into your website, every single visitor to your website has to connect to these third parties' web servers in order for those scripts to be loaded. And here we see CDN. CDN is a prefix for a content delivery network. And on a site like the BBC, it might be considered as necessary to have a CDN. The BBC has a massive audience, a global audience, particularly this one. This is bbc.com, which is the international website. And as a result of that, it may be a situation where content loads slower if it's not on a CDN, if it's not on a content delivery network. So say, for example, you're in, let's just say, Brazil, and you're trying to read the BBC's articles, particularly the news articles maybe in relation to the Ukraine war, as a trusted news source, then it could be that because you're so far away from the BBC, which is based in the UK, that those pages might load a bit slowly. So as a result of that, we use content delivery networks, which effectively cache content on a server which is closer to the end user. Just one minute, Kinu, and I'll get onto that shortly. So it could be a situation where that content is being cached on a server closer to the customers or the users in Brazil, so that they can see that content faster, so there's no lag on there. So there are certain circumstances where a CDN would be justifiable, but in most circumstances it isn't. Unless you have a website which is attracting millions of visitors every single day, then the chances of a CDN having any significant impact on your ability to deliver content at a reasonable speed is minimal. The chances of that occurring are simply very minimal. So unless you can justify that, and I must emphasize this, if you have a company website that's maybe getting 500, 1,000 hits per day, there's never a justification for having a CDN or using a CDN to load content on that network, on that website. Normally reserved for things like big news sites, big media companies, or busy websites, particularly maybe gaming sites or web forums, etc. But for most business websites, unless you're a large company, using CDNs isn't justifiable. And the thing with the CDN is effectively you're connecting to that CDN server. So every time you connect to that CDN server, details about your device can be collected and stored. And obviously, if CDNs have wide availability, so for example, we see the CDN Optimizer.com. Optimizely is a very heavily deployed tool across the web. It's almost ubiquitous, which means that many websites will have this script in there. So every time you go to a website that has this Optimizely script, they're in a position where they understand which website you come from through referrer headers, which we'll talk about in a little bit, and they can build a profile based on you. So they can take a fingerprint of your device, or they can use their logs, or they can store a cookie on your device, which then they can use to monitor the different websites you visit based on their presence or their ubiquitous presence, and build a profile of your interests. And they sell this to third parties for advertising purposes and various other revenue sources. So there's a definite risk in forcing people to connect to third parties. If we look at fonts, GStatic and fonts, Google APIs, these are both Google fonts. When we talk about things being strictly necessary, it's absolutely not strictly necessary to embed these fonts directly from Google servers, because you can store these fonts on your server. There's nothing in the terms and conditions of Google's fonts which prevents you from serving these directly from your own web server, which means they don't meet the requirements of what we consider as strictly necessary. Because if you remember at the beginning of this, I said that in order for something to be considered necessary under EU law, then it must be the only way of doing something. If you can do something in a way which is less impactful in a negative way on the fundamental rights of the data subject, in this case, privacy and data protection, then that's the route you must take. So clearly here, given the fact that you can store the fonts directly on your own web server and not bring them from Google server as an embedded asset, then you can reduce or mitigate the risk to privacy of those individuals by not embedding these as third party, by having them on your first party website. And the same thing is true of things like frameworks for CSS or JavaScript frameworks, which are used to create nice effects on a website. Often they're loaded via a CDN. They shouldn't be loaded via a CDN. They should be embedded first party. And the reason why this happens is really down to just lazy web developers. And I say this because I've been developing websites since the early 90s, when the web first came onto the internet. And nowadays there are so many frameworks and so many tools and libraries, JavaScript libraries and various other things out there, that developers, they just go out, they grab them, they throw them into the website on a CDN, without understanding anything about them, without taking any consideration of privacy or data protection. It's just a convenience thing. They want to be able to do the latest crazy thing on the website that's going to catch your attention, create that hit of dopamine, and to damn with everything else. So it's really important that where it isn't necessary, you don't embed third-party resources into your website. If it's a security tool, for example, to detect spam, then it might be valid. Things like Google Capture aren't strictly necessary because there are various other captures available on the market which you can host first party. Every time you have a capture from Google embedded on your website, again, Google is able to track them. And Google tell people that they don't monitor the use of Google Fonts. But if you go to Google's own Google Fonts website, and I did this last week in a session I was giving at Privacy Spaces, which was a new privacy conference in the UK last week. If you go to their website, you can see statistics on the right-hand side of the screen showing how many times fonts have been downloaded, which devices they've been downloaded from, what the operating system is on those devices, etc., etc. So for Google to claim that they're not monitoring the use of Google Fonts is a complete fallacy. They clearly are. This is how they have this information, and they publish it directly on their Google Fonts website. And on that same website, it shows, and this was, bearing in mind, this was last week, by Thursday last week, Google Fonts has been viewed globally 70 trillion times. Just to put that into context, that is a huge, huge number. It's completely intangible for most people to understand what 70 trillion is. For most of us, a million is a lot. Nowadays we're getting into the realms of billions, particularly when we're talking about finances. But a trillion is just huge. A trillion is a huge amount. And then 70 trillion just goes beyond that even further. So Google Fonts, as of last Thursday, had been viewed 70 trillion times, and Google is collecting all the information about the people who connect to their servers in order to load these fonts from these embedded, where they're embedded into websites as third parties. So don't do it. Just don't do it. If you're going to use third-party fonts, put them first party. This is the same things like Font Awesome, which is these icons that developers put all over websites, home icons and mail icons and social media buttons, etc., etc. A lot of the time they're also embedded as third-party content. It's not necessary, so don't do it. So in all situations, when we're talking about strictly necessary in the ePrivacy Directive, we're not just talking about cookies. We're talking about any access to or storage of any information in the terminal equipment of the end user. So bearing in mind that every time you embed something like this, all of these files, these are files, get stored on the device of the end user. That's how the web works. We send a request to a web server. That web server then sends data back if that data exists, if the request is valid. And it's sent as a file, which is then stored within your device, normally in the browser cache or somewhere else within the browser. Sometimes they're stored in memory, but even memory is then stored on device as a page file. It's getting very technical. I'm not going to go technical on this session, but just suffice to say that any script, any image, any CSS file, etc., which is in your website, is being stored on the device of the end user. So the first part, storing information on the end user's terminal equipment, is always satisfied with every asset from your website. Gaining access to information already stored on the end user's device is any information which goes back. So for example, when you send a request to a web server to send you a specific web page, when you click on a link, for example, you're sending certain information to that web server by default, and there's nothing you can do about this. These are called HTTP and TCP headers. As I said, there's nothing you can do to control these headers. They're part of the web standard and the networking standards for TCP/IP protocol. And they include information such as your IP address, which is the unique number which identifies your device on the internet. Things like the user agent string, which is the type of browser that you're using. In this case, on this server, we're using Brave browser. And we're lucky to have Pat from Brave here today, their DPO, good friend of mine. So all these things are sent to the web server when you make a request for a web page. Other things include things like the fonts, or they can include the fonts, the resource that you requested, so the page or the images that you requested, whether or not you were sent from another web page, so we call that a referrer header, etc., etc. So there's a vast amount of information which is sent from your device to the web server of the website or the apps that you're using every time you interact with that, even just loading the page in the first place. So that satisfies the second condition. So we've got storing information on the end user's terminal equipment, which is all these scripts, and then we've got accessing information. Because all of these things which are sent in the HTTP and TCP headers are originating from the device, then it's considered as accessing information. And the big difference between the ePrivacy Directive and GDPR is that GDPR is only focused on personal data. So anything which is not considered as personal data is out of scope of GDPR. But the ePrivacy Directive has jurisdiction over any information which traverses a public telecommunications network. And this type of data we were just talking about, this header data which gets sent back to the servers when you make a request, under the ePrivacy Directive, this is considered as traffic data or metadata. And there's a very strict purpose limitation when it comes to traffic data. And when we talk about purpose limitation, we mean that the things that you are legally allowed to use this data for. And in the case of all this header data or traffic data, as I said, there's a very strict limitation. It can only be used for the purpose of facilitating the transmission. So in other words, to be able to send messages backwards and forwards between the web server or the app server and your device. Yeah. And the other one is for billing purposes. So ISPs, for example, need to understand, or used to, nowadays it's not so much because things aren't monitored from a subscription perspective. But it used to be that your connections would be monitored based on the amount of data that you use, and as a result of that, they would be able to track some of this data for billing purposes. Also for calling people, if you're making a phone call, they need to understand the endpoint and the initiating point that the call is being held over. So who you're calling and where you're calling from, how long you're on the call, and various other metadata, again for billing purposes. But these are the only reasons that it's okay to use this data from a legal perspective. So you can't argue that, well, okay, the browser is sending this data already, so surely we can use it. No, you can't. As I said, that strict purpose limitation on traffic data under the ePrivacy Directive forbids it. So until you get consent for further use of that data, you can't use it. And one of the problems with this is web servers generally, when you set them up, the default settings are very privacy invasive. So they log a huge amount of data, which is stored in files on the web server and then can be used. And it's still considered as personal data under GDPR in many respects. So for example, any of the session data relating to an IP address would be considered as personal data. And it still falls under the jurisdiction of the ePrivacy Directive as well. But these logs, if you don't change the default settings on your web server when you set it up, then you will find that it's logging a massive amount of data by default. You're responsible for that. You have to do your due diligence as an organization or an individual who's serving web pages and make sure that you comply with the law. And this means you need to understand what this means for your logging as well. Now, there are some legitimate reasons for logging, for example, to prevent certain types of security incidents, so distributed denial of service attacks, for example, to deal with things like fraud, other cybersecurity issues. But generally speaking, these can be covered in other ways without having to log this data in a web server directly. They can be used ephemeral logs which only last for a very short period of time. Yeah, and as DM said, for solving technical issues in general. But there still needs to be a legal justification, what we call a legal basis, and making sure that you minimize the amount of data that your logs produce, and making sure that those logs are deleted on a periodical basis in order to meet the storage limitation principles of GDPR is very important. So it's not just about the cookies that you have installed on your website. It's not just about the fonts and other things which are being used within your website. Also, the way that your web server is logging information needs to be taken into consideration as well. And the reason why I'm talking about this today is because there's been quite a lot of regulatory action around these types of technologies recently. So there's been an enforcement action over the use of Google Fonts being embedded, which cost the company a lot of money. There's also been an enforcement action against the use of Google Analytics, being based on the situation where it's sending personal information to Google. And we're starting to see more and more of this, and we're going to see more and more of this as time goes on. So being aware of what your obligations are, understanding how your websites and apps work, and understanding the type of data which is flowing in and out is critically important. Thankfully, the BBC don't have a Facebook pixel in here, not that I can see anyway. But things like tracking pixels from the BBC are also covered by this, or from any other website. Also, how many of you are engaged in email marketing? Just quickly raise your hand or say something in the chat. Do your companies engage in email marketing? Okay, no answers. All right, I'll go on. It's important to understand that ePrivacy Directive also applies to email, because email allows you to access and store information on the end user's terminal equipment, their mobile phone or their computer or their tablet, etc., etc. When you send an email, if that email has embedded pixels or scripts which forces the user's device to connect to a server in order for you to monitor and see whether those emails have been opened, requires consent. There are legitimate ways of facilitating message opening to understand whether your message has been read. We call these read receipts and delivery receipts. These are part of the email protocol. And in order to facilitate a read receipt, the person who receives the email must consent to that. They have to give their explicit consent to send a read receipt. So you go away with the issues that we face regarding consent. Using transparent pixels and various other tools within emails for marketing purposes is illegal without consent, because it's requiring you to store information which isn't strictly necessary, because you don't need to know when somebody reads the email in order for the person to be able to receive that email. It's something which happens after the fact. And most of the email tracking services, or the mass mailing email marketing services like MailChimp, etc., have got these tracking pixels in, and some of them have them in by default, so you need to actively go in and remove these tracking pixels, or you need to make sure that you get consent to use them at the point where you collect the email address from the individuals in order to send them these marketing emails. Same thing applies for email newsletters. So it's a vast landscape when we're talking about ePrivacy. We're talking about a lot more than most people might think. Also, smart devices. So if you have a smartwatch, a fitness tracker, if you have a smart car, or let's say you've got a smart toaster or a smart fridge, which are becoming increasingly popular, particularly the smart fridges. Things like Withings scales. I have a complaint launched against Withings now for about the last 3 years on the data that they're collecting from their scales, which isn't strictly necessary, and is health data, so it's an even bigger issue from a GDPR compliance perspective. So all of these devices, all of these smart interactive things that we have in our homes are generally sending data back somewhere, unless you're very selective in where you purchase these from, and you have a technical understanding of the type of data that they're collecting and sending out. And there are techniques that you can use to prevent that. So you can have firewall rules, which can block external devices from external communications. But that's getting really technical at that point. Most people don't have the technical knowledge to be able to do this on their home networks. And many of the home network systems that you get from your ISP probably don't support this in a really good way anyway. You generally have to buy specialized equipment like an edge firewall or something like that, which we use here. So the scope of the ePrivacy Directive is much broader, and the type of information it covers is any information. It's not limited to personal data. And this was clarified by the European Court back in, I think it was 2019. Now it seems all blurred since the pandemic. But the case was called the Planet 49 case, and they clarified in there that the ePrivacy Directive relates to all information, not just personal data. So you've got to be really careful about how you're building your apps and your websites. A lot of apps nowadays, in fact, I find it increasingly the case that apps embed third-party SDKs for advertising purposes or for analytics purposes. So things like Google's SDKs and Facebook's SDKs, Microsoft's SDKs, etc. Most companies I go into as a consultant have no idea what's going on in their apps. Mostly because they don't build the apps themselves. They hire third-party companies, development or software houses to develop these apps for them. They have no technical understanding and no part in the decision-making process when it comes to the design of the apps from a code perspective. They may understand what's going on from a visual perspective, so they get involved in the UX or the UI design, but they have very little understanding of what's happening behind the curtain. what's happening under the hood, so to speak. And most of the time when I go into a company that has an app, these issues are the first things that pop up. They have various SDKs. Yeah, it was October 2019, I believe October 1st. I filed a complaint with the European Court within minutes of the judgment coming out, because the European Court's website didn't comply with their own judgment. So it's one that sticks particularly well in my mind. They changed it a couple of hours later to make it compliant, but it just goes to show that even the European Court can make mistakes when it comes to complying with the laws that they have the job of enforcing. So we really have to be aware of the things that we're doing in our infrastructure, in our digital assets, both from the perspective of websites, but also all these other things now, such as IoT, the Internet of Things, or apps, different platforms, mobile phones, operating systems, etc., etc. And we try to deal with this. Anybody who knows me knows that I was very heavily involved in the development of the upcoming ePrivacy regulation, which is due to replace the ePrivacy Directive. I helped to write it with the European Parliament. Worked on the drafting team. And one of the things that was in the ePrivacy regulation was Article 10, which was privacy by design and privacy by default, which kind of mimics Article 25 of GDPR in relation to data protection by design and data protection by default. The problem was the Council of Ministers, in their first draft of their proposal, bearing in mind when we have a new proposed law in the European Union, we have a proposal from the European Commission, which then gets analysed by both the European Parliament and the Council of Ministers. Both of these bodies are required to agree before a proposal becomes law through a process called trilogue. But each of these bodies produces their own draft of changes that they would like to see from the Commission's proposal. So in the case of the European Parliament, I was involved in the drafting of that particular document. In the case of the Council of Ministers, the Council of Ministers is made up from representatives from EU member states within the governments of those EU member states, normally ministers, which is why it's called the Council of Ministers. And they produced their draft. And the first draft that was produced by the Council of Ministers in 2017 stripped Article 10 entirely from the ePrivacy regulation, because they didn't want to. We had in Article 10 that any developer of software, whether that be an operating system, whether that be a website, whether that be an app, whether that be software for a smart car or firmware for networking equipment, etc., would be required to meet the principles of privacy by design. As I said, similar to Article 25 in GDPR. And the Council of Ministers, who are often considered as the lame duck when it comes to EU law and fundamental rights, because they're heavily lobbied by industry and tend to be very industry friendly. So they gutted this from their version of the regulation, because they felt that it would pose too much of a burden on companies and create too much liability, and they didn't want to impact the development of IoT or the emergence of IoT, this thing we call Internet of Things, for smart buildings and smart cities and so on and so forth. So they gutted it completely. So Article 10 of the ePrivacy regulation, as it was, no longer exists. Hopefully during the trilogue process it will be re-added. But it is one of the big issues, which is a bone of contention between the European Parliament and the Council of Ministers currently. And if there is no agreement, then the ePrivacy regulation simply won't be adopted. So we're hoping that during the trilogue process there is agreement. But at the same time, we need to be very careful not to water it down, because there's a requirement that the ePrivacy regulation doesn't weaken existing protections under the ePrivacy Directive and GDPR. So by removing Article 10, it could be argued that this is weakening existing protections, because GDPR requires privacy by design, and as such, so should the ePrivacy regulation. So that's one to watch moving forward. But it is a big issue, making sure that you understand what your software is doing, and all your software. So that includes your video conferencing solutions, that includes your marketing solutions, that includes your collaboration solutions, your websites, your apps, etc., etc. You must understand what's going on under the hood. And if you don't understand what's going on under the hood, you have a legal obligation under due diligence to make sure that you can understand, or face the risks of significant penalties as a result. Just keep an eye on the time. So your due diligence requirements would mean that you need to understand how these things work. And as the controller under GDPR, the controller is the one or the organization who is responsible for determining the means and purposes of processing. So essentially, the company who are going to benefit from this. Processors are companies that act on behalf of controllers. So for example, a software development company might be considered as a processor in developing software for a company, for a controller. But most of the responsibility lies on the controller. There are situations where processes can be fine, but they're fairly limited. The buck stops with you. So you need to understand what's going on with the software that you're deploying and make sure that you comply with the law. So ePrivacy, not just about cookies, it's about all of these other things as well. Oh, I see double click in there too. I never noticed that. And as an end user, you can access this. We call this developer tools by simply right clicking on the page and selecting inspect from the menu. And then that will open this up, and then you can look at various things. So elements, console, all the different logs, etc. Sources, where things are coming from. So this is the one that we're mostly interested in. Network memory is where you will find information about cookies and things. So there may be information about cookies, although in here it's not there at the moment. Application is for cookies. Memory is something different. So here we have storage. Cookies are a form of storage, but we also have local storage. We can see we've got local storage here from Google, local storage from a CDN, Optimizely, and then obviously BBC local storage. Session storage is in relation to things which are required for the session that you're in. So that's until you close the web page. That's what we consider to be the session. And then cookies, most people are familiar with. You can see we've got cookies here from Google APIs, from Optimizely, from BBC, etc. So this is where you find this information in the application section. This is on Chrome-based browsers. It might be slightly different on things like Firefox and Apple Safari, but Brave is a Chrome-based browser, so this is where it turns up. So let me close that quickly and get on to the second part of this session, which we're going to talk about the consent management platforms and things like dark patterns. No questions in the chat. Has anybody got any questions on the previous part on ePrivacy in relation to necessity and embedded technologies? Because I'll take a quick break for a minute or two and answer questions if there's any that exist. No? Well, just ask them in the chat if you do have them. Let's get on to the second part now, where we're talking about consent management and whether or not that consent is valid. Now, this again is part of the ePrivacy Directive. And if anybody follows me on LinkedIn, I wrote an article on the truth behind consent banners last year. As somebody who was heavily involved in the consultation for over a year in Brussels on how the ePrivacy changes in 2009 would be implemented in order to provide the relevant information for users to provide consent, there was a series of roundtables hosted by the European Commission, in which I and many others in civil society took part in. And it's an interesting read, so I'm not going to talk about it here because it would take too long. But I recommend, if you want to understand the history behind these banners, to have a look on my LinkedIn profile and look at the articles there. As I said, I wrote an article about this last year, the truth behind cookie banners. Now, this is a cookie banner. This is a particularly bad example of a cookie banner in certain respects. In one respect, the BBC says they would like permission to share your personal data with our ad partners to allow them to show ads tailored to your interests. This is more honest than most. Most cookie banners just say, we store small files to make our website work better, called cookies, or something similar to that, which doesn't meet the transparency requirements. And then they have a little bit here about what that means. So personalized ads for content, ad content measurement, audience insights, and product development. And then here they say store and or access information on the device. So if you remember, when I was talking about the Privacy Directive, I said it's about storing and accessing information on the end user's terminal equipment or their device. So the BBC are fully aware of what their obligations are, otherwise they wouldn't be using this language, yet they still continue to get this wrong. And then here we have two options, do not consent and consent. This button here, this do not consent, has been added in the last 2 months or so, after I filed a complaint with the BBC that they didn't have a way to revoke consent or to deny consent at the first layer of the consent banner. And this is because it must be as easy to deny consent or revoke consent as it is to provide it. So if you have a big consent button on your website banner, on your cookie banner, but no refusal button, then it's obviously not as easy to deny consent as it is to grant it. And you would think here that if I click on this do not consent, then that's it, job done, right? I'll be in a situation where I don't need to worry about it. The BBC aren't going to do anything such as planting information on my machine or collecting information from my machine, and it's all good. But that's not the case at all. If we go into manage options here, we can see, and I did a video recording of this on YouTube, which you can all go and look at if you want to. I'll post a link on my LinkedIn and Twitter profile later. This was the subject of a complaint I filed against the BBC. I just actually had confirmation from the ICO, which is the UK regulator, today, 4 months after I filed my complaint, that they're now willing to start looking at the complaint. They're not going to do anything about it yet. They've just replied to the first email. It only took them 4 months to reply to the email, but they're now looking into this. And the reason why I complained is because this consent banner uses what's known as the TCF, which is the consent framework provided by the IAB for programmatic ads and real-time bidding and so on and so forth. It's a complex ecosystem, and again, I'm not going to talk too much about that today. But under the ePrivacy Directive, there is one legal basis. That legal basis is consent. There is no other legal basis for the ePrivacy Directive. It's either strictly necessary or you have to have consent. There's no legitimate interest, there's no public interest, there's no legal obligation or protection against a legal claim, etc., etc. These legal bases which we see in the GDPR under Article 6, under the ePrivacy Directive, there's only consent. Yet if we look here, we can see legitimate interest all over this consent banner. They're using legitimate interest here, you know, all the way down this scroll page. You can see the use of legitimate interest. Bearing in mind that the requirements are that consent should be disabled by default, which they've done. Okay, so consent is disabled by default, which is one of the things that came out of the Planet 49 ruling. If consent is disabled, then you can never have legitimate interest, because under Article 5 of the GDPR, we have the principles of GDPR, and one of the first principles is that any processing of data must be lawful. And in order for that data to be processed lawfully, it must comply with any other laws which have jurisdiction over that data. And the ePrivacy Directive is a piece of legislation which we refer to as being lex specialis, which means that it sits independently of GDPR, almost above GDPR to a certain respect, for any information which traverses a public communications network. So all of this information, as you can see, I'm on a website, so it's clearly traversing over a public communications network, which means consent is the only legal basis. And in order to comply with the ePrivacy Directive and meet the lawfulness test under Article 5 of GDPR, then they must have consent for any processing of my data under the GDPR. And given legitimate interest as a GDPR legal basis, if I haven't given consent for the collection of the data in the first place, there can be no further processing under GDPR. You stop at Article 5. There is no legal basis. You have no legal right to process the data any further because you haven't collected it lawfully. So in this case, I haven't given my consent, yet these legitimate interest toggles are still turned on. This is completely unlawful, and this is the basis of my legal complaint against the BBC. When I complained about this, the BBC completely refused to do anything about it. They acknowledged that there was an issue. They said that they're working on it. I mean, this has been the law since 2002, arguably since 2012, definitely. So there's no valid justification for the BBC not having a compliance solution in place. And on top of that, they blamed it on their consent platform provider, which in this case, they say is Google. So Google have presented this or provide this as a tool for customers, this consent management platform based on the TCF, and they say there's nothing they can do to turn this off, which is absolute rubbish. I've looked at the solution, and you can absolutely have legitimate interest disabled by default, and it should be in this case. And they say this is for further processing under GDPR, but as I said, if you haven't collected the data lawfully in the first place, by having this consent, which as you can see are all disabled, then there is no legal basis. Do not pass go, do not collect $200, your processing stops there. If you continue to process the data, then it's completely unlawful. So we see this legitimate interest, you have to go in and manually turn them off for every single one. Yeah, and bearing in mind, you may have thought on the previous page where it says do not consent and consent. If you click do not consent, then you would have thought that these would be turned off. But this is what we call a dark pattern. A dark pattern is a manipulative UI or UX which manipulates people into taking a specific action based on either misinformation or interference of some form. And in this case, that's exactly what they did. They put a button to say do not consent. Most people would assume if you click that, then none of this would be turned on. It's not the case. Furthermore, when we look at these sections here, there are no options here. No options whatsoever. You can't turn them off, turn them off or turn them on. It says, so these are what they consider to be strictly necessary or essential technologies. And ensure security, prevent fraud and debug. You could potentially argue that the security and prevent fraud would be strictly necessary, but debugging, not for the benefit of the end user. They would probably be using optimizely under this tag of debugging because it's usually used for A/B testing. But again, you need consent for that. There's no option here to do that. Technically deliver ads or content. We can see they bundled here ads and content. Now, as an end user visiting the BBC's website, I absolutely request content. Yeah, so we could consider that as strictly necessary. But I don't request ads. I've got no interest in seeing ads. It's not strictly necessary. It's something additional which is for the benefit of the BBC. So this should have a consent button here, and this shouldn't be bundled in the first place. You can't bundle consents in this way. That's one of the requirements of the GDPR, that consents must be specific, must be an explicit action with no ambiguity and can't be bundled so that people can make these specific choices. So we've got an issue here. Match and combine offline data sources. Well, if they're going to combine and match offline data sources, what are they combining it with? They're combining it with online data sources, the data that they're collecting from your device by visiting their webpage. So again, the ePrivacy Directive applies, and this should have a consent off by default. Link different devices. Again, this falls under the ePrivacy Directive because it's information which is being sent over a telecommunications network. So this cannot be considered as essential and must be turned off by default. Receive and use automatically sent device characteristics for identification. This is explicitly collecting information from your device. It says it right there in black and white. Receive and use automatically sent device characteristics for identification. They're saying that this is the traffic data or the headers we were talking about earlier on. But as I said, there's a strict purpose limitation on those headers. So one of those limitations is for to facilitate the transmission, and the other one is for billing purposes. Characteristic for identification is not an exemption. So again, this requires consent under the ePrivacy Directive. Anyway, we've gone through all that and you think, okay, I can click on confirm choices and it's all good, right? No. This is just the tip of the iceberg. You then need to click on vendor preferences. When you go on vendor preferences, you can see all of these. And all of these are ad tech, or the vast majority of them ad tech. So this is the information which the ad brokers or the data brokers are collecting and then selling to advertising agencies or putting into their real-time bidding system, etc. And again, we see legitimate interests, and all of these should be disabled by default. And none of these can be used or toggled unless consent is provided, because again, it fails the lawfulness test of Article 5 of GDPR, the principles. So you have to go through and delete all of these, or turn all of these off. Let's go through this process. And bearing in mind, I mean, I'm an expat. I don't live in the UK. I left the UK in 2012. I live in Sweden. And I rely on the BBC as an independent, objective news source, particularly now in the situation that we're in with the pandemic over the past couple of years, but also, of course, with the situation in Ukraine. I want to make sure that the news that I'm reading is objective, so that I'm not stuck in a bubble. So I use a number of reliable news sources, or what should be reliable news sources, in order to be able to understand what's going on in the world, which is why I use the BBC. But I mean, clearly they're in breach of the law here. And if you look at these durations as well, 730-day cookie duration for RevJet. Under the ePrivacy Directive, but more specifically under the GDPR, we have the principle of storage limitation, which state that it should only store data for as long as is necessary. Quite how they can justify 730 days, which is effectively 2 years, for an ad tech cookie or an ad tech collection of ad tech data is just beyond me. As somebody who's been working in this space for near on 20 years now, to see this type of retention policy is just a fine waiting to happen. So we'll see what happens there with the ICO now that they've actually read the email and are starting the investigation. So we go through all of this, and now we can click on confirm choices and we're good. But are we? What's this here? We have another banner at the bottom. Let us know you agree to cookies. Yes, I agree. No, take me to settings. Now, is this the same as the one I've just done? No, it isn't. It's a completely different cookie banner. If I click on no take me to settings, you can see here that's a very different look and feel. We've got strictly necessary cookies on, we've got functional cookies off, and performance cookies off, which is how it should be. But this is a completely different consent banner. So which one takes precedence? Does the one I just went through before with all legitimate interests under TCF take precedence, or does this take precedence? And if I click on see the list of strictly necessary cookies, this is where things get really interesting. List of strictly necessary cookies, there are a shit ton of them. And I would argue that the vast majority of them are not strictly necessary. The vast majority of these could be done in different ways, or could be done as just-in-time cookies if you click on a specific thing which requires a cookie from a third party, or shouldn't be there in the first place. You know, they're not necessary for delivering the service or the content that I've requested. A lot of this is to do with just ridiculous things: sign-in dismissible count, sound stations, tap implicit, tap users, GUID. So GUID is effectively a unique browser ID, which is personal data. I mean, the list just goes on and on and on and on. And the vast majority of these, I would argue, could not be considered as strictly necessary, because they're for the benefit of the BBC, not for the benefit of the end user. So it's really important that when you're looking at websites and you're considering the consent that you want to give to these websites, that you understand what they have listed as their essential cookies, because more and more I'm seeing essential cookies used to hide cookies which certainly are not legitimate. So things for marketing, market research, for monetization, etc., which do not fall into the category of essential cookies. But companies are doing this because when they set up their CMPs, they don't want to give this information to users in the consent banner. And if it's in the essential cookies, then technically they don't have to disclose it, because you don't have to have a consent for essential cookies. Yeah, so they try and hide things in the essential cookies so people won't notice what's going on. It's always important, if you get the option, to look at what those essential cookies are in order to make an informed decision. So this again is an example of dark patterns. Why do I have, or why did I have this consent management solution as well as the consent management solution with legitimate interest from the TCF that I had to go through? Now keep in mind as well that the TCF has recently had an enforcement action against it in Belgium. It's being appealed this month by the IAB, but the Belgian supervisory authority, and this was after considerable consultation with the other supervisory authorities across the EU, they've decided that the TCF, the entire framework, so that entire consent banner that we saw previously with all the legitimate interests, is unlawful under GDPR, and also unlawful under the ePrivacy Directive, because it doesn't provide the transparency requirements in order for people to make an informed decision in order to give consent. There's a whole bunch of other stuff going on there as well. I recommend you read it if you want to. It's a really interesting case. But this is really a big problem, because if you can't understand what's going on the services that you're using, if you're being given conflicting information, or if things are being hidden away from you, or if you're having to go through the same process over and over again, and that process isn't consistent, so here we've got two different consent banner situations, then that leads to what we call fatigue, or consent fatigue, which means we start switching off, we start ignoring these things, and that has an impact on our rights, our fundamental rights to privacy and data protection, as well as various other things. So when we consider how advertising is used to manipulate individuals, and that's really what advertising is. The whole purpose of advertising is to manipulate you into buying something that you may not have thought you needed or you weren't aware of. And sometimes the advertising is good. It provides access to products or services that we actually need. Other times it's not so good. So if I buy a pair of Nikes down at my local Sports Direct or something here in Sweden, after searching for various shoes and doing research for them online, the chances are for the next month or so I'm going to be seeing adverts across the internet for Nikes that I've already bought. So there's really no point in that situation. But this is because all that information has been gathered by these websites where I'm finding this information. So I may go to a popular review website to read about a particular product or service. I may read forums, or I may go to the manufacturer's website, etc. And all of this information is then shared billions and billions of times with lots of other companies around the world. I mean, the amount of data which is being collected about us is absolutely staggering. You may not remember what you did at 12 o'clock noon on, I don't know, February 13th, 2017. But you can guarantee that if you were online or using your mobile phone, Google probably knows about it. Facebook probably knows about it. They know more about you than you know about yourself. And this really came to a head with Cambridge Analytica. Hopefully many of you are aware of the situation with Cambridge Analytica. Cambridge Analytica used a technique known as psychographic profiling. And psychographic profiling takes manipulation to an entirely different level. It was developed in the early 20th century by psychologists as a means to assist marketing. So it had its birth in marketing at the very beginning, which is not a good thing. And it's been used for manipulating people ever since. And the way it works is it triggers specific emotional responses by understanding your psychology, by reading or understanding the things that you're interested in and how you react to things online. That gives deep insights as to your psychology and your emotional psychology more specifically, and then enables messages to be sent to you to nudge a specific and manipulate a specific response from you. We saw this used with great success by Cambridge Analytica in the Trump campaign, in the Brexit campaign, etc., where they literally bought millions and millions of online advertising slots specifically to manipulate certain voters to vote a certain way. So people who they deemed were potentially anti-immigration, or people who were worried that their jobs might be taken by immigrants, they would push their anti-immigration stance by sending messaging such as immigrants will rape your daughters and things. And these were actual messages. I'm not just making these up. They were quite shocking. In order to just nudge people further and further towards that goal of voting for, in this case, a far-right politician who had very strong anti-immigration policies. Same with the Brexit situation. So this level of manipulation now with psychographic profiling, with the massive amount of data that can be utilized to build those profiles, more than any other time in history, has a profound impact on our fundamental rights. And we're not just talking about tinfoil hat stuff, privacy, data protection. We're talking about all the rights and freedoms that we take for granted every single day. Freedom of speech, freedom of association, freedom of thought, freedom of religion, freedom of movement. All of these things have are massively impacted when you take away privacy, because if you know you're being surveilled all the time, then you change the way that you interact with people and interact with the world. You change the things that you say, particularly if you're in let's say a more aggressive regime like Russia or China, for example. You would be very careful about the things that you say, who you're saying them to, the places that you go, the people you hang out with, etc. All of these essential freedoms, which we've taken for granted since the end of the Second World War, essentially evaporate when we come to the level of manipulation through psychographic profiling nowadays. And there's an interesting theory in psychology called the Hawthorne effect, which I talk about a lot. The Hawthorne effect, I studied psychology. My first degree was a joint major in psychology and a double major in psychology and computer science. And one of the things I studied was the Hawthorne effect, which is in relation to how people behave when they know they're being monitored. So when you know you're being monitored, your behavior becomes more artificial. You change the way you behave. So you're no longer making free choices and behaving as an autonomous individual with self-determination and all these other things. You're now behaving in accordance to being manipulated. You know you're being watched, so you're going to change your behavior and make that behavior artificial, which is a big problem in psychology, because in experimental psychology, you're trying to understand how people react to certain stimuli in certain circumstances. And if they know they're being monitored or observed, we call it another name for this is participant observation theory, where people who know they're being observed change their behavior. So there was an interesting experiment with children. So children were put in a room, there was a big button put on a table in front of them, and they were told not to push the button. So of course, as soon as the person left the room, they hit the button, right? Another one has been done with candy. So they put kids in the room, so you can't eat the candy. As soon as the person monitoring them leaves the room, they eat the candy. So, we change our behavior, we change how we behave and the way we interact with the world when we know we're being observed. And this is known as the Hawthorne effect. So on the one side, you've got psychographic profiling, which is manipulating the choices that we make. So those choices are no longer considered as free choices or choices we make independently. They're the subject of manipulation. And then on the other side, we've got all this observation that's going on, or surveillance capitalism, as it's called in our industry, which we're aware of and is making us change the way that we behave because we're being observed. And the impact on society from that is profound. If you consider how that will quantify in a couple of generations' time, will we actually be real people anymore, or will we simply be robots, organic robots, being manipulated? Everything we do is through manipulation by third parties, whether that be governments or companies or NGOs, etc., etc. We no longer have the ability to be free people, to be autonomous individuals, self-determination, understanding our place in the world and making free choices. So we're not just talking about tinfoil hat stuff here, we're talking about a profound impact on future generations, on the whole of society, and also on innovation, because innovation, remember, is reliant on people thinking outside of the box. Okay, so all of these companies say that they're innovative, all these tech companies are driving, or they claim to be driving innovation. What they're actually doing is they're driving us towards a future where there will be no innovation, because people no longer think for themselves. They no longer think outside of the box. And as a result of this, innovation suffers. Because if we can't think outside the box, we don't find alternative solutions other than those which are presented to us by those who have a vested interest in presenting them to us. So it really is a lot deeper. When I wrote another article on the psychology or digital psychology, so it's which you can also read on Medium. I'll put a link to it on my LinkedIn profile later today, where I talk about this issue, where I talk about the issues of manipulation in relation to how that impacts individuals and society. And I talk about this frequently when I'm giving speeches on data ethics. And it's really something which we need to consider, that not many companies at this point in time understand, because they don't understand the technologies that they're deploying. They don't understand the APIs or the SDKs they're using. They don't understand how their web pages and their apps or other software has been developed to include these surveillance tools. And that's what they are. They're surveillance tools. Surveillance isn't something which is just reserved for governments and authorities. Companies are doing this stuff all the time as well. So this is why I'm so passionate about ePrivacy, and why I consider ePrivacy to be my baby. It's been the focus of my life for almost 15 years now. I've been hugely influential in the development of law in this space, including having drafted or helped draft the upcoming ePrivacy regulation. It's something I talk about all the time as well. And this is the reason why it's very different from data protection. Data protection is about protecting personal data, making sure that it's used appropriately, etc., etc. When we talk about privacy, we're talking about much more than data protection. We're talking about something which can have a fundamental impact on everything we do, everything we say, everyone we hang out with, everywhere we go, etc., etc. Question from DM. DM Constantino, we can argue developers don't know either, as frameworks, especially JavaScript frameworks, have an almost endless stream of dependencies. This is true. This is something that I've struggled with personally. So I had to train my developer who develops all my digital solutions for me, because I don't have the time to do it anymore. I trained him for 3 years on privacy by design. And it's still something which is woefully lacking in the development community. I was asked to speak at an app developers conference some years ago now, when I was still working at Privacy International. And they asked me what the topic would be. I said I'd talk about app privacy. Pat will remember this, because he was writing the GSM privacy standards at the time. And their response was, oh, I don't think our audience is going to be interested in that. And you had to question why they chose to invite somebody from an NGO called Privacy International, yet didn't understand what the topic of the discussion would be. And it really was a clear illustration that when it comes to developers, they have very little understanding of what privacy and data protection is. They have almost no understanding of what the legal obligations are. And this isn't something which is being taught either. I approached the European Commission and various global companies and universities and colleges around the world back in 2012, lobbying to try and have privacy and data protection embedded into academic curriculums, both in high school and in college and universities. And there was no interest. No interest by the European Commission, no interest by various companies to sponsor these efforts, no interest by education authorities to implement these solutions either. And this is a big problem. Until we start to educate people on what privacy and data protection is, what your obligations are if you're working in a space where you're creating digital technologies which are going to process this data, then we're never going to get past this issue. There's been a really good solution developed by a company called Ethica, whom I know very well, who created the first privacy by design privacy engineering tool, which can be embedded into the development stack at the very beginning. And it kind of automates, to a certain extent, the privacy engineering process and makes sure that the developers must follow specific requirements in their code at the code level to comply with privacy and data protection requirements. And this was launched the end of last year. This is the first such tool I've ever come across in 30 years of working in tech, where this type of activity has been facilitated through a framework like this. And we need to see more of that. We need more promotion of that as well. I'll hopefully be having Ethica on a show next month talking about FIDES, which is the framework that I'm talking about here, in a new series that I'm going to be doing on alternative solutions and privacy enhancing technologies. But it is something which is really important and very, very late to the party. So it's something we need to really push the boundaries on and make sure that there's more awareness of these tools and frameworks. Kinu says, to a very small extent, they have started to educate kids in very basic terms in Bavaria. Well, that's nice to see, and kind of expected given the environment in Germany. So you would expect Germany to be a country or a member state that pushes this early on. I'm surprised it doesn't go far, but it's better than nothing. The French have done some similar stuff as well. So the CNIL, which is the regulator in France, they've done a number of initiatives in schools around privacy and data protection. But that's an independent initiative. It's not something which is mandated in the curriculum. It's just something that they've gone on as part of their awareness raising program. So generally speaking, it's lacking. And as you said, it doesn't really go very far. It's very basic. My moderator is telling me that we're well over time. This to be expected because this is a topic I'm very passionate about. But I hope that this session has given some idea or some information which you can find useful when it comes to the delivery of digital assets within your organizations, but also as users understanding what is allowed and what isn't allowed in relation to how these apps and websites and smart devices, etc., are collected and processing all of our data, so that you can make more informed decisions when you're going through these consent situations and make sure that you're making a decision which reflects accurately what you want to happen. I can also recommend that you try and use a privacy-focused browser, like Brave browser. I wouldn't recommend Firefox at this point, but that's a different story entirely. And I think if you can use plugins like NoScript and various other privacy plugins which can block cookies and other things from happening, then I'd recommend you look into those as well. But I will be doing more shows on these types of solutions and tools as we move forward. This is only the second show since we launched last week. There will be a lot more information about these types of tools and technologies as we move forward over the next 6 to 12 months. It's been a great pleasure. I'll see you all again next week, hopefully. Oh no, next week there will not be a Wednesday session because I'm in Brussels next week for my Masters in Law. I have to be on campus for a week. So there won't be a session next week. There will be a session the following week. There's also another session on Friday this week at 4 p.m, which is a general Q&A about privacy and data protection. So if you want to ask me questions that I normally charge €250 an hour for, and you want to get that for free, then feel free to connect at 4 o'clock Central European summertime on Friday this week, and we'll do an hour or so, maybe a little bit longer, answering questions there. Thanks everybody, have a lovely evening, and I'll speak to you all or see you all again soon.